welcome to Before You Go, Part 2. This is the second half of a two-part session that was started with Rabbi Tobin a few weeks ago. This afternoon, we're going to hear from three experts teaching us estate planning, the final documents you should leave for your family. That's a final gift you can give to them by having this already. Making funeral preparations and leaving gifts that will survive your memory to institutions that you were committed to during your lifetime. These are all essential things you should do for your family. Do it at a time, although we are living in a weird time. Do it at a time when you're calm and can think reasonably and talk it out with others if you feel you need to. This is being presented by the Culture and Learning Center as part of B'nai Shalom. We're going to ask you to keep your microphones muted throughout the presentation by our three panelists. We want to hear them. They're the experts, and we will get smarter listening to them, but we really need to hear them in order to get smarter while we do it. If you have a question and you know how to use the chat box, please type it into the chat box and be patient because we intend to get to a Q&A session at the end of the presentations so that your question can be answered. If you are not comfortable with the chat box, you will have the opportunity to raise your hand. We will call on you here. And if after we get all done and you think of something after we sign off, please email me at President Deborah, that's DEBRA, at b'naishalom.net, and I will get your question to the person who should be the most knowledgeable as to answer it. Our panel today consists of Lori Houtman, who has spent her career educating the masses about the long-term care journey and the importance of planning for the unexpected. She is a graduate of SUNY Bradenton and Hofstra Law School. Please mute yourself. She is licensed both in New Jersey and New York. Lori is a Department of Veterans Affairs accredited attorneys. Her experience is essential to her role handling her firm's court work, including guardianships, conservatorships, and special needs trusts. She and her husband, Yale, her partner, as well as her partner in life, have personally navigated and helped thousands of families through the complicated and emotional estate and long-term care planning process. She is a featured speaker with the Essex County Bar Association, something that I am quite familiar with, and that is how we have the benefit of her appearing today. William Rose is the funeral director at Jewish Memorial Chapel in Clifton. His cohort, Vince Marazzo, was supposed to be our speaker. However, Vince has opted out because he's retiring. And after this year, I don't blame him. William is a graduate of Rutgers University School of Environmental and Biological Sciences in New Brunswick, and a graduate of the American Academy McAllister Institute of Funeral Science in New York City. He has 15 years experience in the funeral industry, 5 of which have been exclusively with Jewish funeral homes. He's an instructor at the American Academy McAllister Institute of Funeral for 4 years, teaching various subjects, including funeral directing, funeral history, and ethics. He lives locally with his wife, Ashley, and their 14-month-old son, Willie. But the nice thing is he has 2 Labrador retrievers named Winston and Duke. Something tells me he watches The Crown when it's on Netflix. And maybe that's where they got their names. Jeff Lipkin, finally, is the first national director of endowments and legacy giving for the Jewish Agency for Israel, the leading Jewish agency bringing Jews to Israel since 1929. Before that, Jeff worked for the American Friends of Magen David Adom, the Jewish Federation of Monmouth County, Rutgers University, and the United Jewish Appeal, now known as the Jewish Federations of North America. Jeff has visited Israel 30 times and visited Jewish communities in St. Petersburg, Russia, Cuba, Morocco, and South Africa. I went to South Africa a long time ago. Jeff and Paula are 30-year members of B'nai Shalom. With that, I'm going to step aside and listen to our first presenter, Lori Houtman. Thank you, Lori.
Thank you. Thank you so much for having me on this Sunday. I'm happy to be a part of the panel. And I'm hoping that you leave here today learning something that you didn't know before, I'm pretty confident that I will accomplish that. So thank you for the introduction. I am an attorney. I've been practicing for over 30 years. Now I really feel like I'm dating myself, but and this is my specialty. I am an estate planning, an elder law attorney, and I do special needs planning. I often say that lawyers don't always have good reputations. I'm sure Deborah can attest that we are certainly the brunt of many jokes, but often we're always the first profession that people want to go see. But at least for what area of law I do, I always say, I'm helping people and guiding people in a very sometimes stressful time in their life. So let's start to dig in and learn a little bit about today. So the whole concept of establishing an estate plan is to make sure that your wishes are followed in legal documents, and it helps guide your families in making sure that what you want is accomplished. The documents that we speak about, and I'm going to touch about passing away, but I also have to worry about what happens when you live while you're still alive, and the documents that are important for that time. So the documents that we really focus on is a financial power of attorney, a healthcare directive, which in our practice is a combined healthcare power of attorney and living will, okay? A last will and testament, and then we deal with trusts, both revocable and irrevocable, which I'll go into a little bit. But really, it's important to express to all of you that protection starts with good legal documents. That's really important that I can explain that to you, that you need these documents in place, and not having them is preventing you from having a comprehensive plan and having protections in place. So where do you start? And this is where I want you all to start. Do I have these documents I just named in place? And how old are they? Okay. Did I do them 5 years ago? Did I do them 20 years ago? I've had people that hand me wills that their children are now in their 40s and they did them when they had guardians' names. So how old are they? And when did you last look at them? What's in them? I'm going to guess that probably somebody on this, PowerPoint, the Zoom call is going to tell me that they have their documents in a safe deposit box. And I'm going to tell you all to take them out of your safe deposit box, because the problem is that you should have accessibility to them. And a lot of people think these documents are valuable and belong in a safe deposit box, like your jewelry or your dollar coins, like I used to collect from my grandfather. But the reality is that these are valuable documents in a sense of importance, but not necessarily value. A person that breaks into your home, God forbid, doesn't really care about your power of attorney. So more concern is, I always tell people, possibly think about getting a fireproof box from Home Depot, keeping it above floodwaters, because of course we flood in New Jersey. And this way, let all your loved ones know where they are. Because if you pass away and your documents, especially your will, is in a safe deposit box in a bank, the safe deposit box freezes and you can't get into it. The person that can get into it is an executor or an executrix, but you can't get appointed if the will is in there, the original. So again, just a little bit of a tidbit. I always joke that I know that some of my seniors love their safe deposit boxes. I used to go to Century Village to visit my grandfather for many years, and he would take me to his bank every year to visit with the bank people, and he would take me into his safe deposit box, and we would look at all the contents, and he loved that and made me feel special. The idea is that they're great to have, and maybe in the next few generations, it won't have that same importance, but you really have to make sure you have accessibility. Why is it important to look at what's in them in your documents? You could pull out a power of attorney that names a spouse that may not be alive anymore, and you have no alternate person named, no other agent. You could have an alternate name, and that person has cognitive impairment, and there's no other alternate named. So it's really important to take those documents out and look at them, okay? And we'll talk a little bit more about them. But often when you go to doctors and have hospital procedures, they ask you if you have a power of attorney, especially a health one or a living will. But guess what? They never ask you. They never ask you to see it. No one ever asks you. They say, do you have one? And you write yes, but you never see it. And I'm trying to impart to all of you that you want to look at them. I have people that think what they have, for example, they need someone to place them into a facility. They need to make decision-making with regard to psychiatric decision-making, or they need to deal with something with regard to insurance. And they said, I can do that because I have someone X named as my healthcare proxy. And then they hand me the document that they think is the power of attorney. And guess what? It says, do not resuscitate me, do not put me on a feeding tube, do not make, that's a living will. And again, we do a combined document, but that is not appointing someone to have decision-making or placement decision-making, psychiatric decision-making. It's simply saying what you want if you had no reasonable hope of recovery or regaining a meaningful quality of life in terms of advanced life measures. So it's really important that you look at these documents, and that's, it will enlighten you about whether or not the documents need to be updated. By the way, here's what I analogize about your estate planning documents. You know that outfit that's sitting in your closet that you haven't put on in 5 years? Guess what? It may not what? It may not fit you. Same thing how I feel about your estate planning documents. It may not fit you anymore. It may not serve the purpose that you want. Okay. So I'm going to go over and break down some of the documents for you so you have a little bit of an idea of some of the documents that you hear about. An advance directive, and again, I told you we do a durable healthcare power of attorney and living will. It should be written by anyone 18 years or older, okay? So I'm going to tell all of you that have adult children or adult grandchildren, my children that are 21, 23, and 26 all have powers of attorney naming my husband and I because they are legally emancipated. Now, I'm going to tell all of you that the 21-year-old who's still last year in college and the 23-year-old who's in law school, they're not financially emancipated, everyone. And often they're not emotionally emancipated for the amount of times I get called at times, but they are legally emancipated, which means if they're like, especially my 26-year-old, I'll give you an example. He lives in the city, he has his own job, he has his own bank account, he files his own taxes. Should something happen to my son where he's not passed away, but he needs someone to be able to access his bank account, pay bills, handle his tax return, I would not have been able to unless he had named me as an agent under the power of attorney. Just because I gave birth to him, everyone, does not give me any more legal rights to him than anybody else. So again, anyone that's over 18 years of age need these documents. I don't necessarily think a 21 and 23-year-old needs a will, okay? But they definitely need a healthcare power of attorney and a financial power of attorney. So an advance directive provides instruction for future treatment. What happens should I have no reasonable hope of recovery or regaining a meaningful quality of life? What do I want to happen? It appoints a healthcare representative, a proxy, to act on your behalf. But here's one thing I need to explain to all of you. An advance directive does not guide EMS, an ambulance. It does guide inpatient treatment decisions, and it deals with wishes regarding resuscitation and life-sustaining measures. But I live in Livingston, for example. If I, God forbid, had a heart attack and the ambulance came in, they're not going to be saying, can we discuss your advance directive? Is Lori and talk to my husband and say, is Lori have a meaningful quality of life, or is she going to regain a meaningful quality of life? They want to know, am I paddling her or am I not paddling her? Okay. So my advance directive is used later on, but in terms of what is done at the time, the ambulance is looking to see if there's something on the refrigerator, which is a DNR or a pulse that says, don't resuscitate me. Otherwise, they're going to just resuscitate you. I do want to explain, though, that my advance directive that I prepare for my clients does allow the agent to get a DNR or a pulse in the future when that becomes necessary. So for example, if someone says to me, I've had clients say to me, well, why don't I just have a DNR on my refrigerator now? And I said, well, you're vibrant and having an amazing, you're cognitively aware, you're vibrant, you're leading a quality of life. Why wouldn't you want to be resuscitated? That's not what you want on your refrigerator. But the idea is that you want to know that the agent has the power to do that in the future, okay? So really, I'm going to explain a little bit about the documents so you see the difference in them, okay? Now, and that, by the way, that's the advance directive, okay? So, and we do a healthcare power of attorney and living will. They have different clauses, everyone. The healthcare power of attorney appoints a proxy and deals with placement decision-making, psychiatric decision-making. It deals with, where the person's going to live, quality of life decision-making. And the living will part, or that part of the advance directive, deals with whether or not I want to be kept alive on life-sustaining measures, with life-sustaining measures. So then we deal with a financial power of attorney. Please understand they're different, and I don't like ones that mix them together. I prefer you have a general durable power of attorney and a healthcare power of attorney and living will. The general durable power of attorney gives someone you choose the power to act with regard to your finances, taxes, banking, insurance claims. There's a principal, which is the person that signs it, and the agent, which is the person that you're appointing. You want to make sure that your power of attorney is durable, which means there's language in it that says that it stays in effect even when you no longer have capacity. Because even though most times, most of our clients use their financial power of attorney, or their agent will use it when they lack capacity or decision-making, if you have an immediate power of attorney, which I'm going to explain in a minute, it can be for a good reason, like you're in Israel and out of touch and something has to be filed. So the idea, though, is that you want to make sure it's durable so that if at some point you do lose capacity, it doesn't extinguish. And I've seen powers of attorney that are old and don't have that durability language, because that's likely when you're going to need it. Now, I do have people say to me, by the way, I'm very nervous about having a power of attorney and appointing an agent. Not so much husbands and wives, where a husband names a spouse or a wife names her husband, or obviously, wife to wife and husband to husband. We have to be neutral. The idea, though, is that people say to me, well, what happens if I name my child as an agent, and can't they sell my house from under me? They just name it. They can put it on the market. And the answer is, if that's what you're worried about, that your child would do that, then you're not picking the right agent under your power of attorney. This is a fiduciary responsibility, and you need to name a person that would be following and what you would want, that furthers your financial concerns, and that is not doing something that would be against your wishes. Obviously, you can revoke the power of attorney if a person is doing that, but I always say to people that these documents have to have a trust element to it. And I will tell all of you that I have seen the gamut of people saying, I want to name my firstborn because he or she is my firstborn. That is not what I ever advise people. You pick the person based upon the skill set, not based upon whether your child is male or female, or if they've been the firstborn. Because you could have your firstborn child that's great, but has never ever handled any finances and doesn't have any concept of finances, and that would be the wrong decision on your part to have them you're putting your finances in their hands. Now, a financial power of attorney can be springing and it can be immediate. Springing means it comes into effect upon a certain event. Often, the ones that lawyers do will say, upon my lack of capacity or inability to make decisions or whatever it is, I want this agent to be able to handle my finances. I caution you, everyone, on doing a springing power of attorney. I do not like them, and I do not do them often, because that extra step where you have to be declared incapacitated causes a lot of problems when I get them from clients that have done them with other lawyers, because you need to first then, if you have an emergent situation, a stroke, a heart attack, a car accident, and you need a situation where you're handling the finances pretty quickly, you now have to get a doctor to make a declaration in writing, submitted to the financial institutions, who often will push back on the document or whatever with the language in it. I don't recommend it. I really recommend immediate powers of attorney. And again, I know that that would make someone more concerned. And again, then you have to pick the right person. Okay. Again, we talked about who should have one, and that's everyone over the age of 18. You also want to make sure that your powers of attorney are comprehensive and properly drafted and executed. Please don't go to your child that's a real estate attorney or a divorce attorney and get your power of attorney, because they may not have, I'm sure they have it on their Microsoft Word, possibly on their computer, but if they're not comprehensive, if it doesn't have clauses in it that you may need for asset protection, planning in the future, and you lack capacity to execute a new one, you're going to miss out on opportunities, and you're going to have to do a guardianship. And so this is not the time, you know that expression, penny wise and pound foolish, not the time necessarily to take something that's free or get something off the internet, because you in the long run could end up financially in the worse shape than you would have been had you just paid a few extra dollars or got the appropriate attorney to handle it. Okay, this is going to really enlighten a lot of you that are couples out there, and even if you aren't a couple, if you're a widow or a widower or single, the most common misconception is that a spouse automatically has authority to act on your behalf, and that is not true. If something should happen that results in your inability to make decisions and you don't have a power of attorney, I have done guardianships with spouses, several of them already, because they never had the documents in place. The reason why a lot of couples don't have a financial power of attorney in place is that they are lulled into thinking that because most of their assets are joint, they don't need it. Now, if you have a joint bank account or a joint investment account, when you are banking for your spouse, or you think you're banking for your spouse, you're really not. The reason why you have access to that account is because you co-own it. But what is the number one account or the greatest account that most of my clients have that are never joint? Who wants to guess? You're all silent, so you can't say.
Social Security.
Retirement.
Retirement.
Yes, your 401ks and your retirement accounts, your 401ks and your IRAs, which are the greatest assets that most of my clients have are not joint. So I have many people say to me, really? I didn't know that my IRA was not joint. And I said, do you know what the I in IRA stands for? Does anyone want to guess?
Individual.
Individual. It's never joint. Now, why do some of my clients think it's joint? Because they see it on their sheet if they have Wells Fargo or if they have Smith Barney, and they see their sheet. And so it will say non-retirement assets, or it will say, and so it will say things, and you don't realize that the one account is actually a single account, but you see it on a joint statement. So why is that concerning? Look at the number down below. It takes about 3 months to obtain a guardianship in Essex County. It takes 2 months in Morris or Bergen or Passaic. And if you're waiting those months to get guardianship, and nursing home level care costs between $12,000 and $15,000 a month, you're looking at $36,000 to $45,000 that you lost because I can't get your loved one into your documents to provide a Medicaid application or to do any kind of planning. We have no access to it. And that's a reality that we see all the time, everybody. So, and by the way, if I told you that life is completely unpredictable, if you don't know that now after going through this pandemic and seeing that if anybody would have said that we were going to be wearing masks and that we were going to be in lockdowns and we were going to be isolated with an illness that is so random, I think none of you would say you would ever have recalled this. And I talked to my 88-year-old dad, and he told me that the only time he recalls ever having anything like this was when he was a little boy during polio, and he remembers being afraid to go out, or your parents were afraid children go out in the summer but that was a very narrow group of people that it was obviously impacting. But he says that that's like the most sort of like analogy that he can make to what we're all going through. So life is very unpredictable. Okay, your last will and testament. It's a written instruction about how your property is to be distributed upon your death. You designate an executor or a personal representative who will administer your estate upon your death, and allows you to designate a guardian of your minor children for some of you, or a guardian for your special needs children, especially if your children are going to get older and need some guidance. I want to tell you one thing about talking about this area of law. So, and most of you will probably chuckle when I tell you this, although I won't hear you chuckling because you're all on mute. But so when I talk about this, and especially when I talk about, this to my Jewish clients, and it's just so nature of what I come from, I'll say, so, if God, if you pass away, poo, 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 alavai, and my Christian clients go, what the heck is she talking about? Poo, 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 alavai, doesn't make any sense to them. But so I always kind of like feel out my audience before I do it, but I understand that everybody is hesitant to talk about this sort of situation is what happens when I die. And the idea is that you have to talk about it. It is a dialogue to talk about. And I just actually got interviewed for Family Magazine, New Jersey Family Magazine. And they asked me, how do I have this dialogue with my children or with my parents? And I always say to them, it's not easy, but remember that talk that your parents had with you when you were younger. You now have to have the talk with your parents. None of them were easy then, but they're all for your protection. Same, a little bit of a different topic, obviously, but it has to do with opening up the dialogue. Now, I want to explain to you all with your will that one of the things that Deborah brought up to me is that a lot of people watch movies and they think that when someone dies, you sit around a table and you read the will. Okay, well, in New Jersey, we don't do that. We don't sit around a table and read the will. Okay, that's good for movies. One of the things is that what happens is in New Jersey, and we are a probate-friendly state because it's not hard to probate your will. Probate is the process by which you go and you bring your will down to an administrative building in the county in which the person lived at the time they passed away, not died, everyone, lived. You bring down the original will, you bring down an original death certificate, an ID of the executor or the representative, and that is then, they look at the will and make sure it was prepared correctly, and they will then appoint the executor or executrix, and it's not very involved process, and as long as there's no caveat filed or an objection, it's that easy, okay? Not so easy right now because they don't want you going down because of COVID, although we're doing all this now by mail, and so some of the courts are starting to open up now because of COVID, but the idea is that we are a probate-friendly state. But one of the things that comes up with me often is that people say, well, where do I put my items that I want to leave to someone? My Yadro collection, my Chanukia or menorah collection, or, my teapot collection. And the answer is, we don't name those items in your will. Now, sometimes I will do a specific distribution named in a will. Like if somebody says, I want to leave all my jewelry to my daughter, I will put that in the will, or they say, I want to leave my house to X and I want to leave my car to that. But for smaller items and items that you may want some flexibility with changing, we prepare what's called a memorandum of personal property. And what that does is the will refers to that. It will say, I leave my personal items in accordance with my memorandum of distribution of personal property. And that's where you have lines and you write teapot collection to Deborah Grossman, her address, who she is, friend, and then you just simply sign the bottom of this list of sort of distributions, and it doesn't get notarized, it stays with the will. Now, if Deborah Grossman moves out of town and she couldn't keep my Chanukia collection, she moves to a smaller place or whatever, I can cross it out and I can name, Ori Kastner, and she can get it now. So it has applicability to it, and it's really handy, and a lot of people like it. The reason why we don't want to just necessarily name items in a will is that, first of all, what happens if you put in, I want my baby grand piano to go to X, and then you don't have a baby grand piano by the time you die? Or what happens if you come to me to prepare your will and you didn't have a baby grand piano, and 5 years later you do? So this memorandum of property is very handy to be able to have flexibility that your estate planning sort of wishes can continue on once you're done with me. Okay. Next thing is a revocable trust. You may have heard this document. In Florida, especially for my snowbirds, they love revocable trusts in Florida, everyone. Everybody loves them. Revocable, some people call them revocable. Florida loves them, everyone, because it avoids having to probate. And in Florida, they are not as probate friendly as I said we are in New Jersey. It can be dissolved at any time. You can make provisions for a trustee to manage the trust. It avoids probate during the client's lifetime. It is treated, though, like any other asset. So unfortunately, what a lot of people don't realize is that when they come to me from Florida and they say to me, Lori, I set up a revocable trust 10 years ago. I'm so happy I did it. My husband just got diagnosed with Parkinson's. I know we're going to have care expenses that are going to be enormous. I want to protect assets. I want to tap into Medicaid when I can and still have the money that's available to me to keep my lifestyle going. I'm good, right? Because I moved it into the revocable trust. And then I have to say to them, I'm sorry, that trust does not accomplish Medicaid eligibility. It is not an asset protection trust. You then have to move that money into an irrevocable trust and start the clock on the 5-year look back. So they thought they were past it because it's 10 years, but they did not use that trust that would have been available to them even in Florida. It wasn't an asset protection trust, which leads me to the irrevocable trust, which is assets transferred are considered the trust assets. Again, it avoids probate like the revocable trust. It does serve to reduce assets subject to estate taxes. It has those sale capability. It may protect client in the event of a legal judgment, just like the irrevocable trust is your own assets. But it does mostly serve to protect assets from a Medicaid spend out. And so, again, and I don't want you all to be nervous about irrevocable trusts. A lot of people think that they're scary because it means you have no access to your money. That is not true. You just have to access it a certain way to keep it kosher and compliant. So it's an amazing tool to protect assets and allow you to tap into a government benefit to pay for care. Just a little bit of food for thought for any of you that are veterans or have parents that were veterans. There is an amazing benefit out there to help pay for care called Aid in Attendance. I don't handle all different, I don't handle all the VA benefits, but I do handle this one called Aid in Attendance. And if you meet certain criteria, you can collect, this is the current numbers, this is tax-free money to help pay for an aid at home, an assisted living, or a nursing home. And it's an amazing resource that veterans and their spouses do not know about because the VA does not tell you about this, okay? It's a non-service connected pension. It does not arise out of an injury or an illness from the service. It comes because you start needing the aid and attendance of another person. You have to have 1 day of wartime to get this aid and attendance. So these are the war dates for all of you. And don't have to get so crazed if you don't want to, you can't take this down so fast. If anybody needs any educational material, we can email it to you, but this is also on my website, the VA guide, a guide to VA benefits, which is all on my website. So you want to be there 1 day of wartime, and you have to have been at least 90 days of active duty and served, again, and honorably discharged. By the way, I've never met anyone not honorably discharged. Maybe one day I will, but maybe they don't go to lawyers. I haven't met anybody so far. One day, 90 days active duty is important to explain to all of you. You can't have just been in the National Guard, for example. They don't consider that active duty. But you can go into the reserves or the National Guard after, but you have to have had active duty. And I'm happy, by the way, you'll know at the end, I offer free consultations all the time, not just to all of you, but always. And so I'm always happy to look at your discharge papers or your family's discharge papers, which are called DD-214, and it will tell me whether or not the person is eligible. Okay, so I'm just going to briefly touch upon a very important distinction because a lot of people get confused about Medicare and Medicaid. So you see the little cartoon, oh, well, we're both fruit, so like, yes, but we're different fruit, everybody. So that's important, okay? So Medicare, by the way, is the government program that pays, like, think of Medicare as health insurance, a government health insurance program, but you get it when you turn a certain age, and it does not care, the government doesn't care what you have in assets or income. Medicaid is a government program that pays for long-term care, okay? Not health insurance, but they do have an asset test to it. So how does Medicaid work? And please do not think of everyone here, do not think of Medicaid like food stamps. This is a program that a lot of my clients who are middle class or upper middle class are in, because when you factor in a long-term care cost and you don't have a plan in place or you can't tap into Medicaid, we've seen a married couple, one spouse impoverish another spouse on an illness or an injury. And so it's a great resource, and please don't think of it as something for someone else. I have a lot of clients that want to take advantage of it. You just have to plan in order to go on it, because the government wants you to impoverish yourself to go on it. We want you to plan in order to go on it. And again, all kosher and compliant. I'm extremely ethical and above board, and I would never do anything that was not kosher and above board. But again, you have to be compliant and do it in a certain manner. How does Medicaid work? It looks at exempt assets and countable assets. Exempt assets is your house if you're living in it, but not your beach house, not your ski house, not that. One car, the Medicaid recipient can keep. They don't care if it's a Buick or a Mercedes. And life insurance, you can keep term. Whole life insurance, you can't. You would have to cash in the cash value. And that's a shame if you've been paying into it for a payout. And you can keep a lot of your household goods. They don't go through your house and say, how much is this painting's worth and how much is this collection worth? Obviously. If you have a Picasso, everybody, they would care about that. But they don't care about your teapot collection. And then everything else is a countable asset. And here's an example of a single person. In order to qualify for Medicaid, you have to spend down to $2,000 in your name. If you have $50,000 in assets, it won't take long where we live, everyone. Nursing home level care costs now $12,000 to $15,000 per month. Okay? And by the way, that's a healthy nursing home resident. If you needed a ventilator or some extreme measure on a long-term basis, it's $30,000 to $60,000 a month. So now do you understand when I say to you that you could have $2 and $3, $4 million of assets, how easily that could be extinguished? A married couple is a little different. Say you have $500,000 in assets. This is the case that we worry about the most. You would say, oh, well, that's not a big deal. Okay, $500,000, I'll just move, and John is the one that's sick. I'll just move everything over to Sally's name. And that's what happens. They go see attorneys that don't know what they're doing. And they say, oh, we moved the house into Sally's name. We moved the non-retirement accounts in Sally's name. We're really happy that Sally was the one that had the retirement assets. We're good. And then I have to tell them, well, I don't know if you paid the attorney for that advice, because for Medicaid, you're treated as a joint unit, and what they just did meant nothing. You have to get it out of both of your names by moving it into the trust, which is also a house can be moved into a trust. A trust is like a person, and a person can own a house, a primary home, and a person can own a beach house, and a person can own a mutual fund, and a person can own stocks and CDs, and a trust can own those as well. But here's the example of what happens if you don't do planning. If John and Sally do not plan, they will have to spend down $369,360 of their money before John gets Medicaid. If they came to me and did it earlier, they would have the $369,000 in a trust to tap into to enhance the quality of their life. And Sally can still have $128,640 in her name, but they would not be impoverished with just that much only in their name. So again, I'm going to kind of wind down a little bit. 5 points to remember. And by the way, I want to explain something to all of you. A lot of elder law attorneys are estate planning attorneys, but not all estate planning attorneys are elder law attorneys. Okay, that's really important to distinguish. And if your estate planning attorney says that he's an elder law attorney, ask him if he files Medicaid applications, does he do VA benefits? This is a way of kind of distinguishing, because a lot of people know that elder law is like what you want to have on your moniker, but are you really an attorney that really handles asset protection planning and knows how to tap into government benefits? So estate planning asks what happens if I die, and elder law answers what happens if I live and I need care. Because listen to everybody, we all hope that we live a very long life, but the reality is that we can live longer now, and we can live in a needier state, and we are not dying in our sleep like years ago. And the concern is we are seeing people outlive their money. We are seeing people outlive their money. And when I first started practicing 30 years ago, my clients were in their 70s and 80s passing away, and we are regularly seeing into the 90s and 100s. But the reality is they retired at 65, guys. It's not a secret sauce to understand how is it that they're going to take money that they had at 65, even if they're making money and their investments are doing well. You throw in a care cost of $15,000, $20,000 a month. How are they going to last that until their 90s? And that's a concern. Everyone should, whether you're husband, wives, widows, people, never married, children, need powers of attorney. Financial and health, wills and trusts should be updated to address tax planning. By the way, I have seen people hand me wills that are 25 years old and they had no net worth at the time, and it does not have tax planning in it. No credit shelter trust, which New Jersey currently, everyone, does not have estate tax right now. It was done away with by Governor Christie, but we have a new governor, Murphy. They could bring back the New Jersey estate tax, and we had the lowest threshold in pretty much the United States years ago of 675,000. Not when it passed from husband to wife, wife to husband, did it come into play. But when it passed to your children, if your estate had more than 675, which is not hard where we live, everyone, your houses are worth that. There was estate tax owed. So then it raised for 1 year to $2 million, and it was eliminated in 2018. It could come back, though. We don't know. Documents should be updated upon a spouse's death or divorce or any other life event. And you want to plan and act proactively instead of reactively. We always tell people that you want to prepare instead of repair. So I'm going to conclude with this. Life is unpredictable. You need to plan. Stroke, aneurysm, early onset dementia, and now COVID-19, there is no age limit to these health conditions. I had a 32-year-old, I had a mother call me, her 32-year-old had a heart attack a few weeks ago. I have people that have catastrophic injuries and illnesses that are Kessler calling me in West Orange. It's not age necessarily. People are living longer. Money gives you options, everyone. When you have money, you have options. When you run out of money, you run out of options. Planning preserves your money. And long-term care insurance is a piece of the puzzle, everyone, but please don't say, I don't need to talk to an elder law attorney or have an asset protection plan in place, because unless you have a Rolls-Royce policy that's unlimited and has a really good daily rate, you could still need it because it runs out. So how can we help you? We do offer free consultations. You can call our office. A very, very nice woman named Jill will take down some preliminary information so that when you speak to me or my husband, whom I practice with, we can hit the ground running with legal advice. I will look at the documents in conjunction with the consultation, but we do need some background information first. Everything obviously is always confidential. And one of the things that we distinguish ourselves from other lawyers is that we work on a flat fee. That's highly unusual. Deborah probably would attest to that. A lot of lawyers charge hourly. If anyone's gone through a divorce or has a child's gone through a divorce or a family member, hourly gets very costly. Every phone call, every email, everything. So that's a little bit. So anyway, thank you so much for having me, Deborah, on this really nice Sunday day. I hope you learned something today. I hope a little bit of food for thought about what you need to do. So I will defer to my next person on the panel, and then I'll take questions at the end.
Thank you, Lori. Even I learned stuff today, and I have some changes I have to make, although I know what my will looks like. Our next speaker is William Rose, who's going to teach us about funeral planning, pre-planning. And I have a feeling this is a topic that not too many of you have thought about. But in this COVID time, it's the same kind of thing. Be proactive, not reactive. So William, this is your time.
Sure. Thank you, Ms. Grossman. Let me just start by figuring how to do screen share here so everyone can see the slides that I have prepared here. Let's just see here.
Perfect.
All right. Is everyone seeing the slideshow? Great.
Yep, great.
Okay. Now technology is great, isn't it?
And when it works.
Just give me a moment. Let me just go back. Okay, so my name is William Rose. Ms. Grossman already gave me a little bit of a brief introduction. I've been with the Jewish Memorial Chapel for a little over a year. I've been in the industry for 15 years, and I have a lot of experience with pre-planning. A number of you might think it's a foreign thing to pre-plan for your funeral or a loved one's funeral, but believe it or not, here at the chapel, we do about 5 a week, whether it's over the phone. Well, now it pretty much is over the phone. Before, we had a number of appointments where people would come into our building, but unfortunately with COVID, that ended quite abruptly. So if you wish, there is the information for the chapel, including Vincent Marazzo. He's the manager here, but as Deborah said, he's going to be retiring. My information is at the bottom, along with my email and our phone number if you wish to contact us with any of your questions or emails going forward. And if we don't have an answer for you, we're more than willing to hopefully get you in contact with someone that would. But moving forward. So a little bit about the Jewish Memorial Chapel. We were founded in 1921, and we are the first not-for-profit funeral home here in the United States. We originally were in Passaic on Howe Street, and then we moved up to Clifton, a number of years later. The chapel is owned and operated by synagogues and Jewish organizations in the area. So right now we have roughly 12 member organizations. In order to become a member, the organization would have to own a certain number of graves at a Jewish cemetery. So to give you an idea who are members. Reasons to arrange. Most of the time, individuals will like to come here and prearrange because they're trying to spend down their assets to qualify for Medicaid. As Ms. Hopman said before, I mean, her presentation was great and very thorough, and leaves me very little to talk about. But most people have to get down to that $2,000 threshold she spoke about in order to qualify for Medicaid. And the reason for this is you do not want to wait until you have no assets and then you go and apply for Medicaid and then your funeral was never prearranged or taken care of. If that was the case, you would be leaving your family with those financial burdens when the time did come, unfortunately. Also, this ensures that your final wishes are met, and it would ease the stress for your family at the time of death. What we do is we prepare a file with all of your vital statistic information, your name, your address, your parents' names, social security, things like that. And then we discuss the type of funeral that you wish to have. And then we would write out an estimate of costs of what the funeral would cost you today. And then from there, it's up to you whether or not you wish to prepay. Most individuals that are going for that Medicaid target number will prepay because they would like to spend down. So we're just going to talk a little bit about people that are just doing it for peace of mind. And a larger portion of this PowerPoint presentation is regarding folks that would like to spend down to get on Medicaid, and some of the reasons why that they have a great advantage of doing so. So the prearrangement for Medicaid requirements, you want to meet the Medicaid guidelines. Like Ms. Hatman was saying, that $2,000 threshold, right? So you spend down your assets. There are certain things that Medicaid will allow you to spend your money on before you get to that threshold. And one of them on her PowerPoint was prepaying your funeral. Medicaid has a 5-year look back. So they go back 5 years and they look at monies to see the things that you purchased meet their guidelines. So I don't think you can go to Atlantic City and try to double or nothing. I don't know if that would count, but probably not. Some of the funds, like we were talking about, can be protected. One way would be to prepay your funeral using an irrevocable trust fund. Like we were talking about, the money then, when we make your estimate up of what the charges will be today, you would take your money and place it into an irrevocable trust. What that does, it's no longer considered one of your assets, and you've used your money to spend down to get closer to that target. This is also exempt from look back. So this falls under one of their criteria for that past 5-year look back period. Now, an irrevocable trust fund, I constantly have questions from folks saying, well, what's the difference? What, irrevocable, revocable, what's the difference? I want irrevocable because I don't want my kids to touch my money. I want to make sure that that money is set aside for my funeral. Well, not everyone can use an irrevocable trust fund to pay for their funeral. You have to be going on Medicaid within the next 6 months in order for me to apply for an irrevocable trust for you. Now, I'm not saying, don't make arrangements now if that's something you want to do. What we would do is we would use a revocable trust fund. And then as you spend the money down and you get about 6 months out, we will apply to change the trust into an irrevocable trust, what they call a conversion. Now, this irrevocable trust that houses the funds protects your assets because just in the name, irrevocable means that the money cannot be cashed out. That once you put that money into that account, it's locked in and it must be used for the funeral. It's exempt again from the 5-year look back. And what the trust fund includes are the expenses for the funeral, a purchase of the burial plot, purchase of headstone, or the monument. And there's a number of other exemptions that can be included in the funeral bill to help reduce the amount of monies to get you to that Medicaid number. Now, if you notice on the bottom in red or pink, I'm colorblind. It says, do not overfund. Now, why do we not want to overfund this account? Because any of the monies that are left after we complete the burial and we pay for all of these different expenses gets escheated back to New Jersey, right? So the last thing I'm sure anyone wants to do is give their hard-earned money back to New Jersey state government. But they'll be happy to take it if you wish to do that. Now, do not overfund. You cannot withdraw funds for any reason. Like I said, it's an irrevocable account. Access funds do not go back to the family. Like I said, they go back to the state of New Jersey. And although the funds cannot be withdrawn, the funeral details can be adjusted. Now, some folks may come in and make prearrangements and say, I want to put the money aside. I'm going to be buried at King Solomon Cemetery in Clifton or Beth Israel Cemetery in Woodbridge. Well, just like Ms. Hopman was saying, a lot of people's lives change in a short period of time. So you might come in January and tell me about your burial plot in Beth Israel or whatever, and then you decide New Jersey's not for you anymore, you're going to Florida. So you move to Florida. Well, we can do anything you want with that $10,000 that we put aside. It doesn't have to be, nothing is set in stone, in other words. You can alter it however you want to fit the type of funeral that you want. We make the final decisions at the time of death. Now, spending down your assets. Again, you're going to contact an elder care attorney or Medicaid to discuss, the details of that. Again, we talk about a 5-year look back. Transferring funds out of your name to someone else, that might not work. Put funds in a protected trust. We know that works. And pay off debts. That's another option. Now, reasons to prearrange spending down your assets in order to qualify for Medicaid. We already said that's one of the main reasons why people do prearrangements. Ensure your final wishes are met and ease the stress of your family. And they really want to highlight that everyone should have a will, power of attorney, a funeral advocate, medical advocate. They can be, but do not have to be the same person. Now, I want you to understand a number of things. When someone calls us and they say, I'm the power of attorney of whomever that just passed away, this is the type of funeral we're going to be having. I cannot, that means nothing to me. In the state of New Jersey, when you die, the power of attorney ends. The power of attorney is only good while you're living. So in your will, you need to have a codicil within the will, which is appoint someone, a funeral director, basically, that would work on your behalf to make sure that your wishes are met. And most, estate or planning elder care attorneys will know this. In particular, we deal with a lot of families that have that butt heads, that not everyone gets along, which is normal. This is especially important for those type of families where maybe your children or your spouse even may not agree with the type of funeral that you wish to have. So appointing someone that will follow your wishes is especially important. Dealing with stressful situations. Pre-planning does not eliminate stress, but it reduces it greatly for families. It gives you time to think and gather your information before making a final decision. So like I said, we do these probably about 5 times a week. We sit or over the phone, we talk about the type of funeral someone would want, and they come back always and change things. This amount of time of pre-planning, you're not stressed with, okay, the funeral is going to be in a day or 2 days, and you're not put in such a position to make you feel uncomfortable or make decisions that might not be the wisest. It also gives you time to go back and speak with your children or your spouse about how you feel, and maybe you might come up with an amicable solution if your family is torn about the way the funeral should happen. Now, other main reasons to prepay a funeral and when you must prepay your funeral. Again, Ms. Hopman touched on this. What you want to do is spend down your assets. Prepayment of the funeral expenses is an accepted means to protect one's assets for SSI Medicaid. Again, the money does go into an irrevocable trust fund, which we spoke about. Now, these monies cannot be taken out of the trust, hence they're irrevocable. The funeral home can be changed. Now, the same family I was talking about that comes in and makes arrangements with me in January and then moves to Florida, all because they moved to Florida does not mean they have to transfer the account down to a Florida funeral home. What happens is they can go to a Florida funeral home and make arrangements down there, pre-arrangements. And then if something happens to them, the Florida funeral home, all they have to do is send a death certificate to the trust, and the trust will pay them what is in the account. And the account continues to earn interest, right? And it's irrevocable. So the money is never considered an asset of theirs. Again, excess funds are returned to the state of New Jersey, and they're not returned to your family or your state. The reason why I keep bringing this up is some individuals try to use the trust as a method of savings, and they put quite a bit of money in. They plan this elaborate funeral, and then when the person passes away, the family says, "Oh no, we don't want that. We just want, a graveside service and the most simplest of caskets, and we'll take whatever the difference is. You can write us a check back." I'm sorry, but that's not how it works. It's not meant for that. What it's meant to do is care for the person whose money it is. The funds go into an interest-bearing account. Like I said before, these trust funds are, we're going to talk about the actual trust fund itself, but they go into an account that earns interest, and the interest compounds. The trust holder, whether it be the person that we're planning for or the funeral agent that, or informant, as they like to put, will get a statement once a year around tax time, and it shows how much money the trust has earned. Convenience is always a reason. Like I said, we do everything over the phone since COVID. So a lot of email as well, where I send forms, we talk about it on the phone, then the forms are come back to me, and everything is done in your own home. So you really don't have to be involved with the whole COVID aspect of everything. Not having to worry about whom funds will come from at the time of death. Like Ms. Habman said before, things change constantly in your life. Someone who is a middle class or higher has the money now to prepay, but if you were to get sick, as she was saying before, hospital bills, care center, nursing home bills are very expensive, and they can eat up someone's assets very quickly. And then again, you're taking the burden of expense of the funeral away from your survivors. I make a number of prearrangements where that's the main reason why people prearrange, because they don't want to burden their children or another family member with the expense of the burial. This is not a money savings device. This is used to care for the deceased person. Funds go into a secure interest-bearing account. Cost of a funeral is billed out at the time of death, not at the prearrangement. So what that means is that we figure out the estimate of what the funeral would cost today when you make the prearrangement. At that time, you can choose to prepay it or not, but you're actually billed when you pass away, and that bill is put against the money that's in the trust account. The estimate at the prearrangement is used to calculate how much money that you need to put in the trust to cover the funeral bill. Interest is usually close to the increased accrue if the funeral is fully funded. What that means is that you come in, you prearrange, and you prepay today. However, if you live 20 or 30 more years, you're going to say, well, who's going to make up that difference? A $10,000 funeral today might be $20,000 in 20 years, right? Well, the money that you put into that trust is constantly earning interest. that interest compounds, and hopefully after that time period of when you pass, there's enough money to cover the amount of the cost of funeral at that time. Differences between irrevocable and revocable. So on the left, you'll see irrevocable monies cannot be withdrawn. The excess money go to the state, not the family. On the right, you have revocable. These are the monies that can be withdrawn. Excess monies go to the family or to the estate. So we spoke about the irrevocable, talk a little bit about revocable. It works very similar where we make pre-arrangements. If you choose to fund the pre-arrangements, you can put the money away. It still gets interest. It's still FDIC insured. The only difference is in 20 years, you want to go buy a 60-foot Sea Ray boat, you can take that money out and put it towards that purchase. I'm just saying that some people will just want the peace of mind knowing that that money is earmarked for if something was to occur. And that concludes my presentation. We're going to wait for questions.
We're going to wait for questions at the end. I have so many questions to ask, not just for me, but I have a feeling they may touch on a few other questions that some other people have. So that takes us to Jeff Lipkin, who, once he unmutes, we'll be able to hear him. And he will talk to us about gift giving.
Someone's got to they got to close their slideshow out.
Okay, that was
Give me one moment. Give me one moment.
Sure.
I can't read my
We got it.
station.
Click to exit.
Thank you.
Very good. Thank you.
You. Sorry.
Can everyone hear me? I hope.
We can.
Okay, thank you. For the past few years, I've been working to ensure, as many of you know, that the global Jewish community through planned giving. I recently participated in a wonderful webinar presentation on a new Jewish organization. It's called the Jewish Futures Pledge. And it is a worldwide movement to ensure that vibrant Jewish community life continues for generations to come. It calls out for all Jews to pledge that half or more of their charitable giving in their wills will support the Jewish people and or the state of Israel. From Moses to Maimonides, from Herzl to Heschel, Jews have risen to every generation to secure the future of those to come. This is a moment to do the same. By making a commitment, we show to family, friends, and future generations about the importance of sustaining the Jewish people. The Jewish community is at a crossroads. A rising percentage of young people are disconnecting from their Jewish identity in Israel, while Jewish institutions are struggling to attract the next generation. At this important moment, we need to help to ignite a surge in Jewish pride, secure funds for ensure the Jewish future, and spark critical intergenerational conversations about why the Jewish people matter. Right now, there's an unprecedented opportunity to secure the funds necessary for a vibrant Jewish future. Over the next 25 years, a mind-boggling $68 trillion, $68 trillion, will transfer to the next generation. With about $6.3 trillion allocated to charity, which is roughly 10%. We estimate that 20% of this allocation, or $1.2 trillion, will be given from one Jewish generation to the next. What should we be doing to tell the next generation about what was important to us, to our family, how we live our lives, and why do we support our synagogues and Jewish institutions? There's a wonderful book written by Rabbi Jack Reimer called Ethical Wills and How to Prepare Them. The purpose of the book is to each of us to think about what we want to tell the next generation and how we live our lives and what are important to us. For me, it's trying to explain our commitment, Paula's and my commitment to the Jewish community, not only B'nai Shalom, but the totality of our support. When we write a will, we give out our material resources to those we love, and for some of us, what was important to us through charitable giving. That's the use of making charitable gifts in your will. Rabbi Romer tells us that we need to consider to put into writing the lessons of life that we learned and what needs to be passed on to the next generation. Our children may not have the same commitments that we do, but they should know about what was important to us. Some facts: 50% of people die without a will. Of those people who do have a will, about 10% leave gifts to charity. Some of you have heard me talk about using IRA assets to give away. If you're over 70 and over, 7 and a half, been to shul, you've heard that my commercial. You can use your IRA to make current year gifts to pay synagogue dues and other charitable institutions without paying taxes. And that is a good thing, particularly today, since almost 90% of people don't itemize anymore. So I recommend to each of you to think about making gifts, about including making a gift in your estate by using your tax-deferred accounts, IRA and tax-deferred retirement funds, because they are tax-deferred assets. When you pass along to someone other than a spouse, the funds are double taxed. Once of the amount of the original donor didn't pay, and then the income to the new beneficiary. And now there are limits to how quickly the funds need to be dispersed. And so it's easy to designate funds to charities with an IRA. Just go to your fiduciary and there's an easy form. And one thing that I do not recommend is that any tax deferred accounts transfer directly to your estate. Taxes are due. There are many options that we can spend an hour just to review different ways of making a gift in your will. Lori spent a lot of time, and I very appreciate it because I now need to do some more work. Charitable trusts to life income gifts, the options depend on the needs of the individuals involved. I'd like to return to our original discussion regarding our Jewish Future Pledge. What is our responsibility to the next generation, and how can we make a difference to our collective Jewish community? I want to read part of Rabbi Raymer's book is people who have made ethical wills, and everyone should consider making it. It's not a will, it's an ethical will in which you talk about to your next generation, to your children and grandchildren, what was important to you. And I want to read a portion of a letter that a mother sent to their children. You are not born into the world at large, but into a certain family and a certain time. I would wish for you comfort, love at homeness in this family which shares a common historic experience. But I also wish you to always yearning into seeking for something more for yourselves and the generations to come after you. These generations go back beyond Sinai to a lone wanderer, our father Abraham, and continues into the future. It endures so long as this unbroken chain of generations continue to struggle toward an end beyond itself, to be of value to others, to dare to be a partner with that power that causes us to struggle for justice, peace, love, and beauty. So I want to thank you all for listening to my quick presentation. I do plan giving on a regular basis. I'm not an attorney like Lori. I sometimes make believe I'm an attorney, but I always have an attorney looking. So if anybody has any questions, I welcome the opportunity. Thank you.
Thank you, Jeff. I had no thought about an ethical will and the importance of it, and I'm glad you read that passage. I think that illustrated very succinctly why we need to think about, at least if you can, gift giving and what it means to us and pass on to our family in that respect. All right, you've all been wonderful because your mics have been muted. We're going to let you unmute. Go ahead, press the button. Type your questions into the chat box, raise your hand, and have at it. Tom, you're gonna have to unmute. I love your hands, but you have to unmute. There you go. Tom Fon.
Okay, I'd like to take just a minute to talk about the Jewish Memorial Chapel. Bill Rose did a great job about the need for pre-planning, but he didn't tell you very much about the benefit of using the Jewish Memorial Chapel for your funeral service. And we have a relatively unique position regarding that. Charles Kurtzer and I have been the representatives from the shul to the board of the Jewish Memorial Chapel since the shul joined as members in 2012. A number of years ago, we had a member whose parent died. They made arrangements with Bernheim and Livingston. Obviously, the person making the arrangements, a member of B'nai Shalom, was a conservative Jew. A sibling who was more religious, when they found out about the arrangements, they were unhappy. Now, fortunately for the family, the two siblings got along very well. The member spoke to Charles because the member knew that Charles was a representative of the Jewish Memorial Chapel. And the upshot was that they switched from having the funeral at Bernheim to the Jewish Memorial Chapel. They saved, according to the family, about half the price. Remember, the Jewish Memorial Chapel is non-profit. The price was half. The benefits of the halacha being followed were greater than what Bernheim was offering at that particular time. So here the family benefited two ways. They had a more meaningful funeral that addressed the needs of the siblings and the siblings' families, and they also saved about half price. Closer to home, Renee's sister lives in Florida, and she and her husband had made arrangements with a Florida funeral home. God forbid, when they die, their bodies would be shipped north. When I spoke to them about the Jewish Memorial Chapel, they looked into it independent of me having anything to do with whatever they were discussing with the chapel. They switched, which they could do. They told me that the funeral home in Florida wasn't happy, but they, I guess, are bound by law or ethics to honor their change. So they spoke to somebody at the Jewish Memorial Chapel. They made arrangements with the chapel, even though they're permanent residents of Florida, but they would be buried in New Jersey. And again, the savings, the cost savings was significant where it made sense for them to do this. So regardless of all the other topics that have been discussed today, cost is an important element in any transaction. And I can say from a number of sources that doing business with the Jewish Memorial Chapel will be of financial benefit to you and your heirs, your family. And the home is just as compliant and with any other funeral home in New Jersey or anywhere. As a matter of fact, the funeral home is celebrating their centennial year starting in January. The funeral home was founded in 1921. 2021 represents 100 years of service to the community. If you have any questions about what the funeral home offers, you can contact me, you can contact Charles, you can contact Bill Rose at the funeral home, and we'll be happy to help you out or direct you to the right place.
Thank you, Tom.
Mr. Vaughn, well said, well said.
Thank you.
He's my co-presenter.
Yes, he is. He and Charles Kurtzer have been steadfast assistants with the Jewish Memorial Chapel for us for many, many years, and we have profited from it in a roundabout way. The next couple of questions, hang on, Maureen. The next couple of questions in the chat box are addressed to Lori. Lori, can you see them?
Okay.
Yes, so I think Karen asked me, what are the advantages of a revocable trust
Right.
beyond that it can be changed? And can it be used to pay down for Medicaid, or is that only a non-revocable trust? I'll address that first. So that is the big difference between the two. A revocable trust serves to get it out of your estate for probate purposes, but it's not an asset protection trust. So if you have a revocable trust, you're usually the grantor of the trust and you're the trustee. And if you do have a revocable trust, you have direct access to your money, and Medicaid says that that is not a compliant trust for asset protection. I want to explain one thing to all of you guys. And by the way, I learned so much from you, Bill. We'll have to talk more in the future if we have so much synergy with what we do. But the idea is that when you die, everybody thinks everyone thinks your assets go under your will. And that's a huge misconception. When you die, conceivably, you may never probate everybody. If your assets are joint, or you have everything with a beneficiary or a payable on death designation, nothing passes under your will. So when you have spouses, if they have everything that's joint, I'm talking about the first to die, conceivably, you may never probate for the first to die because everything is joint and passes over to the other spouse. So I think what people get confused with is that everybody thinks that their assets pass under a will. So for example, if Ori and I had a business, a checking account together because we had a business, and I passed away, even though my will says everything goes to my husband, Yale, Ori gets that checking account because she co-owns it by operation of law. It doesn't go under the will, okay? Another example, if I have a life insurance policy and I name you, Deborah, as the beneficiary, regardless that my will says that my will assets go to my husband, Yale, you get that life insurance. It goes outside of the will. It's a non-probate asset. So what people don't realize, which is why when I do estate planning for our clients, I don't just focus on your assets that pass under the will. I educate all of you as to where your assets are, because a lot of you don't know how it passes. And you need to spruce up your beneficiary designations as well, because you don't realize that and I'll give you one example, and then I'll go on to the next question. I have senior that had 3 life insurance policies, everyone. She named each of her 3 children a beneficiary of the 3 life insurance policies. Her will said everything got split between the 3 kids. Well, guess what happened? Over the years, her policies lapsed, and so she remained with 1 life insurance policy at the end, which is not unusual. You don't keep your life insurances all the time forever. When she died, the 1 child that had the 1 left is the recipient of that money. That child does not have to share that life insurance policy with any of her siblings. It's a non-probate asset. Now, that child happened to say she was going to do it. But let me tell all of you, it doesn't always work out that way. So you need to really know when you go to an estate planning attorney, please go to someone that looks at the whole picture, because you don't realize that I often find mistakes with people's beneficiary, or I find out that they have a special needs child or a special needs grandchild, and they're leaving money to that child without a special needs trust. They're going to do a huge lot of problems for that, cause a lot of problems for that family if they leave money outright. So there's a lot of things to keep up on. So it is an irrevocable trust that serves as an asset protection trust, not a revocable trust, okay? Somebody asked me, what is my flat fee? How does it work? So if I do a planning case and I do a long-term care planning case, asset protection plan, yes, then if I stay with you and I don't keep track of phone calls or emails or, you have a question that comes up, and that's the beauty of it. If my estate planning that I do work on a flat fee as well, meaning until we get the document signed, you're not on the clock for having the discussion about who you name in the documents. You're not on the clock for reviewing the documents with me, and you're not on the clock for signing the documents. Once we finish, you are not unlimited. I mean, of course, I always pick up the phone or, to do things, but if you make changes, 10 years from now, there would be a charge for it. My flat fee people that are doing long-term care planning, there is no charges for document changes. the VA care program, unfortunately, there is no retroactive cost. So a lot of people say to me, I wish I knew about this when my parent or my grandparent or spouse was going through it. You can't retroactively apply. You have to do it. And first of all, you have to have the care expense. So until they need help with 2 ADLs, activities of daily living, 2 of them. By the way, Medicaid is 3 ADLs, activities of daily living. What are they? Toileting, dressing, bathing, feeding, transferring, or incontinence. 2 of those for the VA, 3 of those to qualify for Medicaid.
I think the
Okay.
next one
So
is
that-
you, Rose. Thank you, Lori.
Yeah, that wasn't for me. Thank you.
Nope. Doesn't look like it. Maureen, Wayne, I only see a frozen picture. If you can, if you like, we can contact Jewish Memorial. Oh, there you are. You're muted. Let's hear your dulcet tones. There you go.
Hi there. Yeah, I just wanted the specific information, if you have a link or anything to it.
Sure, I can forward you our, a link, and then, we could discuss, we can, set up a call if that would be suitable to you.
This is the one I'm talking about that Tom mentioned, right?
Right, it's the same one.
Right.
Yes.
Okay, that'd be great. Just want
Okay,
to learn more about it.
great.
Well, as long as I have Bill's attention for one moment, I have 2 very quick questions, maybe 3. What is the average cost of a funeral today?
The average cost here at the chapel, as long as we stay local, meaning that the person dies locally and that the cemetery is local. And by local, I mean about a 15 to 20 mile radius from the funeral home. You're looking at roughly $4,500 for the entire funeral. And those are the funeral home charges.
Mhm.
In addition to that, you would have your cemetery charges.
Plus cemetery charge.
Right.
Okay. The next thing is, what is the current interest rate on funds that are sitting in a trust?
I'm going to say it's about 1%,
1%.
but that is variable. So as the market does better, just a little bit of knowledge for you. The money is all lumped together with all the pre-need money in the state of New Jersey. It's called the
It's
Choices
pooled.
Account.
It's pooled. It's a pooled
Right,
trust.
right.
Yeah. full account.
So what that means is that they're able to get a better interest rate than you were if you were to put money into a bank savings account.
Okay.
Uh,
And my last question. Our family plots are at B'nai Abraham in Kenilworth. Is that a member of Jewish Memorial Chapels?
No, that's managed by Epstein.
Epstein. Okay.
Yeah, but we work with them all the time.
Okay. Thank you.
You're
Let's see. I have a question for Bill. Marlene, you still on? Unmute.
Happy birthday, Marlene.
Ah, birthday girl. There you go, Marlene.
Hi. Yeah, we had the occasion, Bill, where my father-in-law passed away down in Florida. And luckily, at the time, we were kind of friendly with the owners of Menorah Chapels. And we didn't know what to do, how to get my father-in-law back up to New York.
Right.
And what we found out through Menorah was that you're better off going to the New Jersey, or because we did it through Menorah, obviously, you're better off going to the New Jersey funeral home and have them talk to people in Florida to get the deceased person back to New Jersey than you are to go to a Florida funeral home, because they overcharge you.
Correct.
Like they charge you for like almost a whole nother funeral.
Right. So Lynn, that's a great point. So what happens is if you have a death out of state, you want to contact the funeral home where the burial is going to take place. Because what we do is we have associate funeral homes in all the states that we're used to using. And most of them are either Jewish funeral homes or, and support the halakha type of funerals that we do. But getting back to the financial part, if a family is to call the funeral home where the person dies, in your case, it was Florida. The family then is already basically entering into a contract with the funeral home in Florida. And then they're also going to be entering into a contract with the funeral home in New Jersey. So basically they're paying 2 funeral homes. Whereas if you were to just call the funeral home where the cemetery is, we would take care of all of the arrangements from any state or country for that matter. And it would be a great financial at a discount because we use our connections from doing it so often. We're not paying professional services or anything. And part of the discount is that that funeral home isn't dealing with another family. They're dealing directly with a funeral home. So that's a great point, if that answers your question.
Yeah, I just wanted to make sure that was still the case.